since the establishment of Kenya's Supreme Court, an iconic institution that, along with devolution and the Bill of Rights, stands as one of the most transformative innovations in our progressive 2010 Constitution. As Kenya's apex judicial body, the Supreme Court is entrusted with the sacrosanct mandate to uphold and promote the purpose and principles of our constitutional order. By virtue of its unique complement of exclusive, original, appellate, and advisory jurisdictions, it possesses the necessary authority to arbitrate, to advise, and to guide the institutions of our republic as they perform their roles of giving full expression to the will of the people as inscribed in our Constitution. The Supreme Court, therefore, serves a powerful symbolic role as the highest representation of the values and institutions of justice in our land and the fulfillment of people's determined quest for a judiciary grounded in inclusivity, fairness, justice, and constitutionalism. It was designed not merely to interpret law, but also to resolutely underwrite and defend justice for all Kenyans. 14 years after the promulgation of the Constitution, we continue on the journey of implementing the vision for a stable, secure, prosperous, open, and democratic society grounded in freedom, justice, and the rule of law. And central to this monumental endeavor is the Supreme Court, which has guided the judiciary in orienting the national ideology towards the legitimate pursuit of every aspiration and resisting the temptation to compromise our values for the illusion of political expediency, however well-meaning. 12 years after its establishment, it is difficult for us to imagine how the Republic of Kenya existed for many decades without a Supreme Court. It has helped us reject the many false dichotomies that once constrained our policies and politics, including the belief that freedom must be sacrificed for security and that democracy and stability are mutually exclusive, or that sustainable development is the monopoly of the centralized government. It is therefore fitting that this conference invites us to reflect on the Supreme Court's jurisprudence over the past 12 years. In doing so, we recognize both successes and areas for critique as we consider the court's evolution, its impact on Kenya's constitutional landscape, and its commitment to protecting the rights and aspirations of all Kenyans. True to the court's philosophy, bold honesty is the best policy, and this occasion calls us to reflect candidly on its journey, progress, challenges, and impact. To appreciate the achievement represented by the Supreme Court's creation, we must revisit the hard lessons of the 2007 presidential election crisis. That crisis exposed deep-seated systemic failures and a profound erosion of public trust in our electoral and judicial processes, fracturing the people's trust in the rule of law. Consequently, a disputed election outcome triggered underlying conflicts that nearly drove the nation to the brink of almost total collapse. It was realized then that rebuilding trust and restoring faith in the rule of law was indispensable, and that a credible, authoritative mechanism for resolving presidential election disputes was the only way to prevent elections from threatening rather than renewing our nationhood. The 2010 Constitution, therefore, established the Supreme Court as a unique institution with hybrid jurisdiction, symbolizing its special status. Its exclusive original jurisdiction over presidential election disputes is a legacy of the 2000 never again moment. Its hybrid appellate jurisdiction, which depends on the existence of a unique issue deserving authoritative determination by the court, aims to restore confidence in the judiciary, while its advisory mandate enables state organs and county governments to seek authoritative guidance on best practice for policy formulation and also policy implementation. There is no doubt that the Supreme Court has not been short of critics during the past 12 years. Its decisions have been and will be debated and dissected vigorously. And in a number of cases, disagreements will linger for long. Nevertheless, it would be unduly pessimistic to overlook the court's clear efforts to interpret the Constitution with wisdom, reinforcing pillars of democracy, justice, equality, freedom, good governance, accountability, and the rule of law in a very robust way with immense clarity. Sometimes citizens, including myself agree. Sometimes we don't. But we are bound to respect. It has pronounced itself on a broad range of pertinent issues across legal landscape, and in so doing entrenched certain principles and values as non-negotiable procedural and substantive elements of good policy. It is because the court has been emphatic in its dispositions and firm in its guidance of subordinate courts that Kenyans are confident that their rights are intact and due process is indispensable. In turn, this confidence has fostered courage, openness, and vigor in our society, values the Constitution envisioned for the Supreme Court and the judiciary in terms of being faithful to what the Constitution expected of the judiciary. We can confidently say you have passed the mark. It is therefore quite fair to say that the court has stood as a faithful custodian of our Constitution, a defender of fundamental rights, and a pillar of democracy. Its sustained capacity to resolve complex constitutional matters remains critical to our nation's institutional vitality now and going into the future. Even as we celebrate the court's achievements, we must recognize that there remains some way to go for us to reach the Constitution's promised land, that the pursuit of justice is unending, and that as long as we are free and a democratic nation, competition and disagreement will require resolution. What happens, for example, with a government that has been elected on the basis of a manifesto? What is the place of a manifesto? A program that has been voted for by millions of Kenyans alongside a candidate and a party. What weight does the court put whenever there is a challenge on a manifesto? I would want to invite the court to think about it. How do you respond to litigants, individuals, that challenge a policy and a manifesto position canvassed among the citizens of Kenya, voted by the people of Kenya? And how do we use the place of manifesto to remove politics of personalities and instead try to, consolidate the place of politics that is around a program, a policy, an agenda? How does the court help us to consolidate the place of getting away politics from being about personalities, or sometimes even about ethnicity, and taking it to the realm of issues, policies, programs, and how do we work together to make sure that we consolidate the place of a development trajectory, a program, a national program, backstopped by the people of Kenya through an election and rolled out by an elected government. And sometimes, as was said again by my younger brother Sakaja, if you have a program canvassed by a political party, a government, being rolled out, and sometimes it's not populist. Sometimes, as politicians, you have to balance between being popular and doing the right thing. Sometimes they don't go together. And then you sacrifice your political capital to do the right thing. But then the court on the other side decides to be popular and undermine the agenda that you have. And allow me, Madam Chief Justice, to appear before you on this matter. And I hope I am not abusing the court process, on this matter. I'm just trying to, in a very simple way, to put my thoughts across so that, maybe the court can apply its mind to it and help us, chart this course as Kenyans. Because it's me today, it's somebody else tomorrow, it's the next person the next day. And we all must think about this. So that particular matter is sometimes is a matter that informs some of the things that we do. And I am a layman, but we're told that the court also makes decisions. Sometimes they have to factor in public interest. Where does public interest, populism, playing to the gallery, where is that? How do we nuance it so that it is managed properly and we don't drop the ball? So this is just thoughts, and I'm really happy that Madam Chief Justice has said it clearly that we need to consult more, as institutions. We remain committed to partner with the judicial and legal fraternity in building a more accessible, empathetic, and efficient judicial ecosystem which delivers justice to all in a timely, fair, effective, and accessible manner. Each branch of government plays an important role in supporting the Supreme Court as it leads the judiciary in delivering justice. We are committed to working alongside the judiciary to continue developing a judicial system that honors the aspirations of Kenyans and upholds our Constitution, reinforcing the foundations of our democracy. We must work in unity and with a singular sense of purpose to ensure that the Supreme Court remains a shining beacon of integrity, a trusted guardian of our rights and freedoms, a champion of the rule of law, and a leading force in producing progressive jurisprudence, not just in our country, not just in our continent, but also globally. Beyond serving as the ultimate arbiter, the Supreme Court is a driver of national development. Its decisions shape our institutional framework, define our socio-economic landscape, and guide our path towards an equitable society where justice underpins our development. in guiding our institutions to articulate the national values and principles of government as coherent parameters of sustainable development. The Constitution designates the Supreme Court as the umpire charged with auditing policies to ensure that they promote inclusive growth and economic empowerment. When it supports access to essentials like health, housing, and education, it strengthens the foundation for inclusive policies that uplift communities and break poverty cycles. As recognized and amplified by the Supreme Court itself, the greatness of our nation is based on fidelity to the Constitution and the rule of law. Our commitment to constitutionalism and the rule of law is the bedrock of Kenya's quest for prosperity. Consistent and fair application of the law builds trust, encourages civic responsibility, and fosters social cohesion. By championing a jurisprudence that simultaneously upholds fundamental rights and freedoms while supporting development, the Supreme Court helps Kenya achieve Vision 2030 and also our bottom-up economic transformation agenda.
While the Supreme Court and the other courts, especially the High Court also, and the Court of Appeal, have helped us start developing crucial jurisprudence on important issues like public participation, like public interest, and how we handle the tensions between these broad interests with individual rights and freedoms, which are also powerfully protected in our Bill of Rights. I, as a student of law, I'll be interested to, going forward, hear or learn what the Supreme Court and the other superior courts will tell us about, beyond public interest, whether there are other higher interests. And I'm saying this with a bit of bias, Your Excellency, because it's in the public domain. I'm the immediate security minister for our country after you appointed me 2 years ago. And during those 2 years, I have had to ask myself whether the highest interest is the public interest or there is a higher interest called the national interest. Because the public itself could hurt the national interest. And the Constitution talks about the national interest in two places, at the beginning and also in the chapter on national security. Other than the parameters and principles that the courts are helping us to understand about public interest, are there other higher values, primordial, existential, fundamental principles which are crucial to the existence of Kenya? Because the public can be mobilized or can mobilize itself to do the wrong things that threaten the existence of the state. And therefore, that is the next frontier of jurisprudence I would invite us to start thinking about, and the Supreme Court can help us in that regard. I'm happy to be here to celebrate what our Supreme Court has done for the last 12 years. And it's a good thing that our Supreme Court has decided to introspect and reflect, even as they usher themselves into teenage. Because now they are 12, so they are entering teenage, and the responsibilities and the experiences of teenage will obviously visit their experience. And therefore, and that is on a light note, I'm very careful, Your Excellency, because I am an officer of the court, so I'm very careful what I say. I don't want to be accused later of saying that the Supreme Court is entering teenage in future. Your Excellency, allow me to say two quick things before I invite you. The first one is to appreciate what our Supreme Court has done to create formidable jurisprudence on major public interest issues and major public matters of public and national importance. In the short time the Supreme Court of Kenya has existed, the jurisprudence has been quite groundbreaking. And on that front, I think it will be unfair for any assessor to actually fault the performance of the Supreme Court. To deliver the public good called justice, of course, the court has to do that through its jurisprudence and through the decisions they make. The court has also done very well in terms of the infrastructure, the software, the technology bit. And among the arms of government and the agencies of government, I think the judiciary is ahead of the rest of us. I remember my Lord Chief Justice Maraga when we were confronted with the predicament of COVID, issued certain rules, which we now call the Maraga rules, practice rules, which actually made justice, faster, more efficient, more convenient, even if we were all locked down by this public health emergency called COVID. And even after COVID lapsed, it appears that the way of the future in the administration of justice will be through the virtual courts and making sure we spend little time or as less time as possible in physical engagements in courtrooms. So again, on the issue of technology and the software for delivering the jurisprudence or delivering justice, the Supreme Court has done a good job.
There is need, therefore, for checks and balances between the three arms of government without overreach or interference. Comity of the three arms of government is a cornerstone of our Constitution. Mutual respect is a necessary condition for the coexistence of the executive, legislature, and the judiciary, all who have one clear calling to serve the citizens of this great nation. Through landmark decisions, advisory opinions in moments of national impasse, and precedents, we have strengthened our democratic foundation, and I believe the Supreme Court has continually sought to ensure that justice prevails for all Kenyans. This conference offers an invaluable opportunity to reflect deeply on the court's journey and to consider its impact and future direction of its jurisprudence. We will examine the paths paved by our decisions on critical issues, including presidential election disputes, constitutional questions, human rights, devolution, and so much more. The range of conference activities include public lectures, panel discussions, moot courts, interactive exhibitions, and stakeholder engagements, where we seek to enrich understanding and encourage dialogue about the future of the Supreme Court. It is my honor and privilege to welcome you all to the Supreme Court at 12 Jurisprudential Conference. In early March this year, the judges of the Supreme Court of Kenya during our annual retreat realized that the time has come for us to engage the Kenyan public, including ordinary Kenyans, civil society groups, members of the bench, members of the bar, and academia, as well as state actors who are affected by our decisions in their work and in their lives. We also determined that we would engage our colleagues in other apex courts, both in the African region and globally, to assess our progress as a court and to ensure we remain on course as guardians of the Constitution. It has always been the rule of thumb, however, globally, that judges speak only through their judgments. However, in the contemporary world, judges often find themselves under intense scrutiny and criticism without a chance to respond or engage, even to clarify, if need be, the reasoning of their decisions. Traditionally, judges have had no platform from which to speak apart from the courtroom, from where, in an adversarial system of justice, at least one party leaves unhappy. This conference is therefore conceived by the desire to demystify the court's role and processes and to correct misconceptions about its mandate by deepening public understanding of the court. While judges are not infallible, in a democratic space, the public need to be afforded structured engagement where, from time to time, they can learn about what judges do, where they sit, when and how they do their work, and most importantly, why they do it. This is the reason we are all here today and this week to share, to engage, to learn, and to reflect.
On behalf of the Supreme Court of Kenya, I am most delighted to welcome you all to this conference as we commemorate 12 years since the establishment of the Supreme Court of Kenya. Allow me to particularly single out for special mention and recognition my brother and sister Chief Justices and judges from other jurisdictions who have traveled from across the continent and the world to join us for this conference. Let us appreciate our esteemed guests. The theme of the conference, reflecting and introspecting on the Supreme Court of Kenya's jurisprudence, 12 years of defending the Constitution, captures the dual purpose of our conference, which is to celebrate the milestones we have achieved while critically examining the journey we continue to chart as Kenya's apex court and the ongoing commitment to uphold justice, to uphold constitutionalism, and to uphold the rule of law. At the heart of this conference is the idea that institutions matter. Institutions are the anchors of our democratic aspirations. The establishment of the Supreme Court as the ultimate interpreter and guardian of the Constitution embodies the expectation that the Supreme Court provides stability, certainty, and predictability in resolving the inevitable conflicts that arise within our society. Therefore, we are affirming the idea that our future lies in building strong and robust institutions that will serve as the catalysts for the national progress and development. Your Excellency, ladies and gentlemen, over the past 12 years, the Supreme Court has played a transformative role in shaping both Kenya's jurisprudence and shaping our country's socio-political development. This court's landmark judgments have influenced the daily lives of Kenyans while reinforcing the core principles of our democracy. Through hearing and determining 4 presidential election petitions over the last 3 election cycles, the court has set critical benchmarks for conducting free, fair, and transparent elections. Likewise, through the landmark advisory opinions on devolution and the relationship between the bicameral houses of parliament, the Supreme Court has developed guiding frameworks that clarify interactions between the National Assembly and the Senate, reinforcing devolution as a cornerstone of our transformative Constitution. Furthermore, in defining the parameters for constitutional amendments in the BBI case and establishing principles of public participation in the BAT and recently in the Finance Act cases, the court's jurisprudence has strengthened the democratic foundations of governance and harmonizing the judiciary's benchmark on the areas of public participation that still requires parliamentary action. The court's decisions have also directly addressed issues of land rights, human rights, social and economic justice, and family law. In the same vein, the courts have addressed housing rights jurisprudence in the Me Too Bell cases, which reflects the court's commitment to socioeconomic rights. The courts has set jurisprudence guiding the families on how to uphold the family as the cornerstone of our society. In this and countless other judgments, the Supreme Court has affirmed its role as a transformative agent in the society. Despite the inevitable pitfalls of perception or capture that come as a result of the court's invitation to address political questions, the court's jurisprudence has purposefully harnessed the Constitution as a powerful tool to promote the well-being of individuals and driving societal transformation for the common good. Notably, the decisions of the Supreme Court of Kenya have garnered significant respect and citation across the region and beyond. This recognition in the global legal community underscores the court's maturity into a respected institution whose well-reasoned judgments contribute to the evolving discourse on the law and justice worldwide. For the Supreme Court to continue fulfilling our mandate effectively, close interinstitutional and collaboration and support are vital. Upholding the rule of law and protecting constitutional rights is a collective responsibility that calls for cooperation and respect among the judiciary, the legislature, and the executive, and other state agencies. I therefore call on collaborative relationship that will strengthen our resilience of our legal system and allow the Supreme Court and the wider judiciary to serve as a true pillar of justice. Over the past 12 years, the Supreme Court has played a transformative role in shaping both Kenya's jurisprudence and shaping our country's socio-political development. This court's landmark judgments have influenced the daily lives of Kenyans while reinforcing the core principles of our democracy. Through hearing and determining 4 presidential election petitions over the last 3 election cycles, the court has set critical benchmarks for conducting free, fair, and transparent elections. Likewise, through the landmark advisory opinions on devolution and the relationship between the bicameral houses of parliament, the Supreme Court has developed guiding frameworks that clarify interactions between the National Assembly and the Senate, reinforcing devolution as a cornerstone of our transformative constitution. Furthermore, in defining the parameters for constitutional amendments in the BBI case and establishing principles of public participation in the BAT and recently in the Finance Act cases, the court's jurisprudence has strengthened the democratic foundations of governance and harmonizing the judiciary's benchmark on the areas of public participation that still requires parliamentary action. The court's decisions have also directly addressed issues of land rights, human rights, social and economic justice, and family law. In the same vein, the courts have addressed housing rights jurisprudence in the Me Too Bell cases, which reflects the court's commitment to socioeconomic rights. The courts has set jurisprudence guiding the families on how to uphold the family as the cornerstone of our society. In this and countless other judgments, the Supreme Court has affirmed its role as a transformative agent in the society.
I really want us to appreciate the judiciary of the Republic of Kenya. Because, Your Excellency, without them, this would not be a destination for investment. We congratulate you for the number of years that you've had. We have had ups and downs in this country, but everyone has always known that there will be objectivity in your findings. But your objectivity also must not mean popularity. It must mean just doing the right thing. I was thinking this morning when I came, what does it feel like to be a judge of the Supreme Court? I don't know, Emeritus Mutunga, how does it feel like? Chief Justice Maraga, it's almost a godlike. The finality of your decision. You know, I would draw you to one of the points by Khalil Gibran on punishment and crime. And he speaks to it. That must be exercised in a way that is judicious. Because ultimately, the ultimate judge is God. I really admire the judges of the Supreme Court that we have. You exemplify, that attribute that this country must be. And even us in other arms of government, we look up to you. On behalf of governors, I thank you because you have stood for devolution. You have supported devolution in this country. I remember as a senator marching to court, we frog marched our speaker. He didn't want to go. He's now a governor, Lusaka, he's governor again. We told him, you must go. Because at that point, we felt devolution was under threat. The deputy president was also there, marching to the court, Professor Kindiki. But we found solace. And many times, the judgments will not be popular to us or acceptable, but they must be respected. And so I am happy that we have judges who are immune to popularity. You don't have to make a decision whether that is popular. Leave popularity to President William Ruto, Professor Kindiki, PCS, and ourselves. We are the ones who want to be popular with the people. But for you, just do what is right, as sober as a judge, and our country will remain solid. Because you have a strong and firm judiciary, we have the rule of law. We have a court that can stop a presidential inauguration, and also a court that can quickly, swiftly, following the due course, swear in a deputy president. After other institutions have finished their work, Kenya is a destination for investment. I really want us to appreciate the judiciary of the Republic of Kenya. Because, Your Excellency, without them, this would not be a destination for investment. We congratulate you for the number of years that you've had. We have had ups and downs in this country, but everyone has always known that there will be objectivity in your findings. But your objectivity also must not mean popularity. It must mean just doing the right thing. I was thinking this morning when I came, what does it feel like to be a judge of the Supreme Court? I don't know, Emeritus Mutunga, how does it feel like? Chief Justice Maraga, it's almost a godlike. The finality of your decision. I would draw you to one of the points by Khalil Gibran on punishment and crime. And he speaks to it. That must be exercised in a way that is judicious. Because ultimately, the ultimate judge is God. I really admire the judges of the Supreme Court that we have. You exemplify, that attribute that this country must be. And even us in other arms of government, we look up to you. On behalf of governors, I thank you because you have stood for devolution. You have supported devolution in this country.
While the arms of government are independent, we serve the same citizens and the same republic. And as such, inevitably, all arms are interdependent. I urge each of us gathered here, within the judiciary, the executive, and the legislature, to champion this spirit of interdependence in our approach to public service. As members of the judiciary, I also urge you to continue taking a firm stance against corruption. The Supreme Court has the power to set precedents and to reinforce the standards of integrity and fairness that echo through all sectors of our government. I appeal to all of us in public service to be beacons of honesty and transparency that our citizens look up to and expect. The Supreme Court is the keeper of the promise of democracy and justice. Every decision made here impacts not just today's Kenya, but the Kenya of generations to come. Today, we are on a journey together. The Supreme Court does not exist in a vacuum. It exists in a society to serve the society. The African proverb, which you all know, reminds us that if you want to go fast, go alone. If you want to go far, go together. Let us be steadfast partners in building a just society, one where the rule of law protects every Kenyan and guarantees their rights and freedoms. As we continue in this partnership or interdependence, let us commit to strengthening our institutions, enhancing the capacity of our staff, and encouraging a renewed spirit of service to wananchi and for the national interest. This is our collective duty. Together, we can realize a more just, prosperous, and equitable Kenya. Since its establishment in 2010, the Supreme Court has been the final arbiter on issues of justice that go to the heart of our national conscience. The matters you discuss here today, from the traditions of apex courts to the nuanced balance of judicial independence and accountability, are central not only to your mandate, but to the very core of our democratic system. The Supreme Court is more than the apex court. It is the conscience of our Constitution. The Constitution of Kenya guarantees the independence of our three arms of government. Yet, while we are independent, we are not isolated. We are distinct, yet we are part of the same fabric that is Kenya. Our citizens do not separate us into the judiciary, executive, and legislature. They see only one government. And the expectation is for a government that works as a unified body to serve their interests, their needs, and their aspirations. Ladies and gentlemen, while the arms of government are independent, we serve the same citizens and the same republic, and as such, inevitably, all arms are interdependent. I urge each of us gathered here, within the judiciary, the executive, and the legislature, to champion this spirit of interdependence in our approach to public service. As members of the judiciary, I also urge you to continue taking a firm stance against corruption. The Supreme Court has the power to set precedents and to reinforce the standards of integrity and fairness that echo through all sectors of our government. I appeal to all of us in public service to be beacons of honesty and transparency that our citizens look up to and expect. The Supreme Court is the keeper of the promise of democracy and justice. Every decision made here impacts not just today's Kenya, but the Kenya of generations to come. Today, we are on a journey together. The Supreme Court does not exist in a vacuum. It exists in a society to serve the society. The African proverb, which you all know, reminds us that if you want to go fast, go alone. If you want to go far, go together. Let us be steadfast partners in building a just society, one where the rule of law protects every Kenyan and guarantees their rights and freedoms. As we continue in this partnership or interdependence, let us commit to strengthening our institutions, enhancing the capacity of our staff, and encouraging a renewed spirit of service to wananchi and for the national interest. This is our collective duty. Together, we can realize a more just, prosperous, and equitable Kenya. Thank you.
For the last 15 years, we have concentrated our infrastructural development in the outlying and marginalized areas, but time has come to direct our attention to the Supreme Court, the Court of Appeal, and the Kenya Judiciary Academy, which have no proper home at all. We appreciate the high-level discussions that were led by Your Excellency this morning to the effect that we should have an engagement between the judiciary, executive, and the county government of Nairobi on this issue. Over the past decade, Your Excellency, ladies and gentlemen, over the past decade, the judiciary has received only 50% of its necessary funding, which has adversely affected its operations. Supporting the judiciary as a public good is crucial, and it plays a vital role in protecting individual rights, promoting economic stability, and maintaining a fair and orderly society. Ensuring adequate funding for the judiciary ultimately benefits everyone and strengthens the foundation of a healthy democracy. We want to change the philosophy that underpins budget allocations to the judiciary so that it is based on the number of judges or cases or the justice needs instead of an artificial or incremental basis. We need to introduce some science and empiricism in financing judiciary needs. Despite the challenges that we continue to grapple with, I take pride in the excellent support that the court's registry has provided to the judges since the court began its operations. The registry at the Supreme Court has successfully adopted technology in its processes, including e-filing, and has expanded its reach to 3 locations through sub-registries, and therefore enhancing convenience for court users. As we celebrate these milestones today, let us renew our commitment to justice and progress.